Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we talk about the Petition to Determine Parental Relationship, also known as Form FL-200. If you are filing this form, you're asking the court to determine paternity of a parent to the child or children at issue in your case, and the parties are unmarried. So through that determination of paternity, you can request child custody, visitation, and child support orders. In order to start off this form, as usual, you want to fill in your identifying case caption information at the top. Leave the case number blank for now, since this is a new case. A case number has not been assigned yet, and the court clerk will write that in for you. This form can be filled out either by the mother or the person that believes themselves to be the father of the children at issue. If you are the mother, when you're filling this out, line 1 wants you to identify the role of the petitioner. So if you're the mother, fill in mark box 1A that states you gave birth to the children listed in item 2. If you are the father, you would fill in or mark box 1B that states you want to be determined to be the parent of the children in item number 2, and then you have to give your explanation as to why. It can be something as simple as, I believe I'm the father of the children. If you have been previously determined to be the father, and I don't mean in an official capacity, but either you're believed to be the father of the children, or maybe when the child was born and you were in the hospital, you signed a voluntary declaration of paternity, and now you want the court to make a finding that you are not the parent of the children in item 2, then mark box 1C. If there has been someone appointed to be the child's personal representative, and that is the person filling out this form, mark box 1D and state the court and date of that appointment. And line 1E, you would mark if you are anything other than these 4 categories of options listed above. Line 2, you're going to fill in the child's name, birth date, and age. If it's a child who's not yet born, mark the box that says to be a child not yet born. Line 3, the court needs to know if it has jurisdiction over the respondent. So either the respondent lives in this state, has had sexual intercourse in this state, which resulted in the conception of the children listed in item 2, or if there's some other explanation as to why you believe the court has jurisdiction over the respondent, you can list that here. Item number 4 wants you to explain why the action is being brought in this county. So either the children live or are found in this county, or a parent is deceased and proceedings for the administration of the estate have been or could have been started in this county. Line 5, you're going to check all that apply. So if you believe the respondent is the parent of the children listed in item 2 above, you would mark 5A. If you believe that parentage has been determined by a voluntary declaration of parentage or paternity, you would mark 5B and attach a copy of that form to this if available. If you believe that the respondent is the children's parent and has failed to support the children, you can mark 5C. 5D, if someone has paid for the expenses of pregnancy and birth for which the respondent should pay, then you would mark 5D and list the name of the person that has paid for those expenses, the amount, who is paid, or who it should be paid back to, and for what it was paid. I will say on 5D, if this is an older child, I probably wouldn't request reimbursement of expenses of pregnancy and birth, but if this is a fairly recent birth, then it makes more sense to request this. 5E, if public assistance is being provided to these children, you want to mark that box that lets the court know that. And 5F, if there's anything else you think the court needs to know regarding the establishment of paternity in this case, you would mark 5F and specify what that is. This form does need to be served along with a summons, as well as the declaration under UCCJA, that's your form FL-105. Page 2, you're going to identify what it is that you want the court to find. So either you're asking for one of the parties to be found to be the parent of the children in item 2. If you're the mother, you're obviously already been determined to be the parent. But if you're asking for someone to be found to be the father, then you would mark the box that states who that person is. Again, if we're in our unusual scenario where you're asking to not be found to be the parent, then you would list or identify the party that you do not want to be found to be the parent in 7B. 7C has to do with genetic testing. Whenever there's a paternity case at issue, either party has the right to request genetic testing. So if you want to exercise that right, mark 7C, and then state if you want the genetic testing to determine, and then identify which party you want the genetic testing to test to be determinative of who is the parent of the children listed in item 2. Assuming that the genetic testing comes back positive and we are able to establish paternity, you can request custody visitation orders through this form. So if the party that is at issue regarding paternity is found to be the parent of the children listed in item 2, then you can request legal custody of the children, and you would identify which party should have legal custody. If it's joint, mark joint. Same with physical custody. And then if you are requesting one party to have primary physical custody, then as far as visitation goes, you should mark the box for the other party to have visitation. There are some forms you can attach to this that have some really specific custody visitation provisions. I generally don't use these forms. I like to keep, at least in my petition, a very broad outline of what I'm asking for so that I'm not boxed in and prohibited from asking for something later on down the road. But that is entirely your choice. 8E asks for you to provide the facts in support of the requested custody visitation and parenting time orders, and you have the option of attaching a declaration. Again, I try and keep this simple. I would just write something like best interests of the children. I would leave my declaration for either a trial or if I'm requesting any sort of temporary orders via a request for order. So that's just me. You obviously have the option of attaching a declaration if you want to get more specific. If you are requesting reimbursement for expenses of pregnancy and birth, then you want to mark the box that states who should pay those. And again, as follows, provide some sort of explanation. And again, if this is many years ago, I probably would not request this, but if it's fairly recent, you certainly have the right to request it anyway, no matter what. But in terms of succeeding on this request, I would say that if it's many years ago, it's probably not going to be granted ultimately. Fees and costs of litigation. If you're asking for any sort of contribution to attorney fees, then you want to mark the box that states attorney fees to be paid by. And then if there's any sort of experts that you're anticipating being appointed to this case, you can also mark that box that states that one or the other party should pay for those, or both parties. If you are requesting a child's name to be changed, then you can mark the box that says 11. Children's names be changed, and then you need to specify what their current name is and what the name change is that you are requesting. Item 12 just states that the court can make orders for support of these children. And then 13, if there's any other orders you're requesting relating to the children, custody, visitation, support, you can mark box 13 and specify that there. Type your name at the bottom and sign and date this, and then this will need to be served once it's been filed along with the summons, the declaration under UCC JEA, as well as a blank response to petition to determine parental relationship on the respondent. I hope that you found this helpful. Good luck.